Broadcasting on Spice FM 94.4 in Nairobi, 102.5 in Kisumu, 87.9 in Mombasa, 96.7 Eldoret, 96.0 Nakuru, 90.9 in Nyeri. Malindi, we're on 97.7. And for this hour up to 9 o'clock, we're also on KTN Home. Welcome to our audience on KTN Home. Let's begin with today's proverb by C.T. Muga.
This is an African proverb. The child who is not embraced by the village will burn it down to feel the warmth. Not cryptic. Well, not very cryptic.
Not very. Child who's not embraced by the village will burn it down to feel the warmth.
Yes.
You'll explain this in detail.
In detail.
As we continue.
And in due course.
Very good. Now, this morning, the Office of the Director of Public Prosecutions is going to be hosting an event, which is the launch of Guidelines on Decision to Charge 2019 and Case Management System. The decision to charge. Now, remember, the Office of the Director of Public Prosecutions is a constitutional office that was basically removed from or hived off from the state law office, the Office of the Attorney General. Because initially, the powers to prosecute were vested in the Attorney General. Now, that was removed from that, and we created an independent Office of the Director of Public Prosecutions who shall receive instructions from nobody, who shall have sole discretion on what happens when it comes to prosecutions, especially of a criminal nature. And the DPP also has powers, actually, to even order for investigations, asking the DCI or the Inspector General of Police to commence an investigation on a matter that has come to his attention. And after he receives the report, he makes the determination whether this is sufficient to prosecute or not. And during the entire process is independent. Now, that decision to prosecute, as you can imagine, is not an easy one. I mean, it's a heavy burden or heavy responsibility, not burden, heavy responsibility that has been bestowed on this office. How does the DPP make a decision? How do the investigating agencies understand the reason why the DPP chose to agree with their recommendation to prosecute or reject the recommendation to prosecute?
Well, the talk I'm thinking, so what sort of individuals would populate this particular department of government? What sort of qualifications must they have? What understanding of the law must they have? What backgrounds beyond just the understanding of the law must they also have? Because as you say, this is not a simple thing that they've been asked to undertake.
It's not a small office.
No, it isn't.
It is a very, very important.
In fact, the word burden that you sort of like use and then withdrew is it shouldn't be withdrawn. It's a burdensome office.
I was withdrawing the word burden because it feels negative. It's a negative connotation.
Yeah, like it's more than you can bear, right?
So I said, let's call it responsibility.
It is a heavy responsibility.
Very heavy responsibility.
Yes.
So this morning that they are reviewing now 2019 and 2020 procedures on how the decision to prosecute shall be taken by the Office of the Director of Public Prosecutions. Of course, it's an office. So it's not just the DPP. Even the people who work under the DPP, some of them are senior enough to go ahead and recommend prosecution. Of course, the DPP maybe has to in the very end in some cases. But then we need to understand all this. So we're joined by somebody who's a senior assistant director of public prosecutions in the ODPP. This is Victor Mule. Good morning, Victor.
Yes, good morning.
Welcome to the Situation Room.
Yeah, thank you.
Now, Victor, we are seeing that there's this launch of what is going to be the guidelines on the decision to charge and case management system.
Sure.
We are starting from that point of saying this is a heavy responsibility that has been bestowed on the Office of the Director of Public Prosecutions, that they have to make sole decision and discretion to charge.
Yes.
How do you arrive at that decision to charge, even before we look at the new guidelines?
Even before we look at the guidelines, thank you very much for calling in. In making the decision to charge, the Office of the Director of Public Prosecutions is guided by what we call the two-stage test. And the two-stage test involves, one, the evidential test and the public interest test. I'll just explain in a minute what they mean. Of course, the first one, the evidential test, we look at the sufficiency of evidence, and all this is derived from the Evidence Act, one of the laws of Kenya. And there are 6 considerations which a prosecutor makes. Once we receive a file from an investigation file, agency, either the police, the Ethics and Anti-Corruption Commission, KRI, we take into account 6 aspects. The first one is admissibility. Is the evidence admissible? The second one is availability. Is the evidence available? The third one is credibility. Is the witness credible? The fourth one is relevance. Is the evidence relevant to this case? Remember, all cases, all offenses have got essential ingredients which the prosecutor must prove before a court of law, so that the court can find the suspect guilty or not guilty. So the evidence must be relevant to the particular offense. And then the last one is the strength of rebuttal evidence. Okay. And rebuttal evidence is the evidence offered maybe by the adverse party to disprove or contradict the evidence presented by the prosecution. That is the evidential test, and it is the first test which a prosecutor considers. If the file does not satisfy the threshold for the evidential test, the prosecutor must rest his tools there. You don't consider the second test, which is the public interest test.
Okay.
The public interest test is derived from the Constitution itself. And remember, the Constitution is the supreme law of the land. And under Article 157, Sub-Article 11, the Director of Public Prosecutions is supposed or obliged to have regard to public interest. Now, what is public interest? Public interest is what is good for the common public. And I want to distinguish this with what interests the public. It is not what interests the public. It is what is in public interest. What is good for the common
it's not what is trending.
It's not what is trending. You would find people maybe holding demonstrations telling the DPP, charge this person with this offense. People will trade in social media, do this. No. That is interesting to the public. It might not be in public interest. Public interest is what is in the common for the public. And there are 7 considerations under public interest. I will just go through them very fast. The culpability of the suspect. How culpable is it? What is the level of involvement? The second one is the impact or the harm to the victim. You know, all crimes have got a victim. It could be a member of the public or even the government itself. So what is the impact to the victim or the community? What is the status of the victim? Then the suspect's age at the time of the offense. These are some of the things we consider. If it's a child, for instance, do you want to a child offender do you want to rehabilitate him, or do you want to maybe incarcerate him in prison or some other remand where you will never benefit as a child? And then the impact, public interest, the impact on the community, the impact of the offense, and the greater the impact, the more likely that a prosecution will be mounted by the office of the DPP. And whether there is a proportionate response, whether prosecution is the best. If prosecution is the best, remember we have alternatives to prosecution. And one of them, we call it diversion. Maybe later in the show you will ask me about diversion. And then maybe you plea bargain. You could also do asset forfeiture or recovery and say that is sufficient and the like. And then we also consider whether the sources of information require protecting in public interest. So those are the main considerations. But as I said, the key word is you start with the evidential test, and if you are satisfied that the 6 tenets of the evidential test are been accomplished, now you go to the public interest test. But if you don't you don't satisfy the evidential test, you rest your tools, and the file is closed at that stage.
Irrespective of public interest.
Irrespective of public interest. If you don't satisfy, remember, you cannot go to court just to please the public. And if you go to court, the court will be bound by the law, and the law is you prove the case beyond a reasonable doubt.
Okay.
So, Victor, who's involved in this process then? I just want to look at one specific thing that you spoke about just a few minutes ago, where you talk about then deciding whether you want to prosecute, if your intention is to incarcerate, along those lines. How many people are involved in this process, or is it the investigating officer who then uses, his points of prerogative to say, all right, this, or his or her points of prerogative to say, this is what I'm going to do? How many people are involved in this process before you reach a decision that now comes out into the public?
In Kenya, currently, we have 129 court stations. Each court station has got a prosecutor who has delegated powers from the Director of Public Prosecutions to make the decision to charge. But I will add this. There are some cases which only the Director of Public Prosecutions can give consent.
Okay.
For instance, anti-corruption cases, it has to be the Director of Public himself who makes the decision to prosecute. Of course, you know the structure of the office of the DPP, and the level of making decisions starts from the DPP, its deputies, and downwards that way. So, in short, for petty cases, the police will go with the file in the morning before the duty prosecutor in the 129 court stations. They will present the file. The prosecutor will study the file, analyze the evidence, and apply the 2 tests, starting with the evidential test. If there is sufficient evidence, the charge will be registered, and then it will go through the trial process, the judicial process.
And
now,
this is the same process across all 129 courts?
All the 29 courts. But I want to put a rider. There are some complex cases which have to be compiled by the investigating agency, that is the Directorate of Criminal Investigation, Ethics and Anti-Corruption Commission, KRI. Then they compile the evidence, present it to the DPP. The DPP will allocate a senior prosecutor or a team of prosecutors to study and analyze the evidence and make a legal brief. They will prepare a legal brief for the Director of Public Prosecutions, and they will still apply the 2 tests, whether the evidence is sufficient, reliable, and whether there is a prospect of a conviction. Once they prepare that brief, the brief now and again looks at their brief, their opinion, their legal opinion, and now makes the final decision.
You know,
and
this,
yes.
What you're saying is truly informative. I actually feel that my understanding of the law is increasing in leaps and bounds. Let me just ask this question. The training that people in your position have and those who are in the judicial system have, at some point are similar, are they not?
They are similar.
Yes.
All prosecutors are professional advocates.
Yes. Now,
and all judicial officers are professional advocates.
Yes. So how then is it, with all these procedures and all these wherewithals that we have, how then do we hear of situations where a case goes to court and we're told there was insufficient evidence?
Now, you see, when the evidence is compiled, it goes to court. And once it is presented before court, there are very many factors. When during investigation, you'll find that we have obtained documents, we have recorded statements from witnesses. Now, when we go to court, some of the witnesses may not come. That is one. We might go to court, we present a document, it could be maybe a secondary evidence, that is a copy, it might not be admissible for one reason or the other. And then the other factor, there could be evidence which was in possession of the accused persons, which now, what I called under the the strength of rebuttal evidence. Evidence might be produced by the suspect,
but the defense
to contradict the evidence adduced by the prosecution. And also, we have situations, and that is what the DPP is fighting. Situations whereby witnesses are influenced by persons in authority. And that's what the DPP is fighting.
To change their
persons
statements.
In authority, pardon?
Their influence to do what? To change their statements.
Yeah, to change their evidence, either not to come to court. The evidence might even disappear because these people have been allowed access to their offices. They might influence witnesses or even make evidence disappear or some other undue influence on the prosecution.
Yeah.
So there are very many factors why a case might not go through.
We'll come back to the big cases. I want to go back to what you called the petty crimes. And these are the ones that an investigator goes to court, presents the evidence to the prosecutor in a court station, one of the 129 court stations countrywide.
Yes.
And here, as I understand it, it's also in the discretion of this prosecutor to decide whether it meets the thresholds, evidentiary and public interest.
Yes.
What recourse does the investigator have if, for example, they present a case and they solidly and strongly believe that there is something to take to court here, and then the prosecutor just looks at it and because he doesn't like this guy, decides, no, this one we can't take to court?
Thank you very much for that question. The guidelines we are launching today have got a provision for conflict resolution. If the investigator feels that the decision made by the duty prosecutor is not the correct one, he has a recourse to the immediate supervisor of that particular prosecutor. In all the 129 stations, we have senior prosecutors who are in charge of the station. I will take, for example, I'll give you Makadara.
Okay.
You know Makadara and Kibera.
Yep.
There is a duty prosecutor who is not necessarily the head of the station. If the investigating officer is not satisfied with the decision, he can go to the supervisor. If again the supervisor makes a decision which the investigating officer is not satisfied, the investigating officer now, through the investigating agency, the end of the investigating agency, say the DCI, that is the Directorate of Criminal Investigation, can now write to the Director of Public Prosecution to say, we investigated this case, we took it to court, it was rejected for these reasons. In our opinion, we think there is evidence. And now the case, the Director of Public Prosecution again will allocate the file to a senior prosecutor within the office of the DPP, again do a legal brief to the DPP, and a decision will be made.
What about in instances? That's coming from one way to the other, where the investigator believes that they have a case and then the prosecutor does not agree with them. How about in the other way around, where the prosecutor is looking at what has been presented before them and they can clearly see that this does not meet the threshold, and yet just by looking at it you can see this is because of the shoddy investigations that have been done?
Yes, we still have such instances, and what we do is we communicate in writing to the investigating agency, to the head of the investigating agency. It could be the KRI, ESCC. We communicate in writing and point out, frankly, the points which are outstanding, which must be covered, And if there are any other measures which should be taken in the interim before these outstanding areas are covered, we mention them in writing. And even if you look at the Constitution, it says the office of the DPP or the Director of Public Prosecution shall communicate in writing, communicate such communication in writing. So if the prosecutor thinks there is evidence, or evidence can be obtained through further investigations, we do it in writing and recommend further investigation. And then we also recommend if there are any interim measures to be taken, maybe like you give the suspect police bond or such like measures.
We are speaking with Victor Mule. He is a Senior Assistant Director of Public Prosecutions in the Office of the DPP. This morning, the ODPP is launching guidelines on decision to charge 2019 and a case management system. We still want to understand the processes that the DPP goes through in taking a case to court and managing that case through its life in the judicial process. And this is what Victor Mule is basically explaining to us this morning. It's broadcasting on Spice FM every morning, and Monday, Tuesday, Wednesday, 7 o'clock to 9 o'clock. We are on KTN Home. We are discussing the Office of the Director of Public Prosecutions and the powers to prosecute, and they're now launching new guidelines this morning on this particular matter. Speaking to us is Victor Mule. He is the Senior Assistant Director of Public Prosecutions, of course, in the office of the ODPP. And just before we went to the break, Victor was telling us, taking us through how the decision to prosecute is arrived at various levels, from the ODPP's office, the ODPP himself or herself, to the other officers, the prosecutors in the 129 court stations. Before we went to the break, Victor, I told you that we're going to come back and talk about, the protection and upholding of human rights and people's liberties, especially when the ODPP has such immense powers. And I'm borrowing this from an opinion that has been published this morning on the Standard, page 16 of the Standard. And this is by Senior Counsel Fred Ojiambo, who says the power to charge must be exercised carefully. He basically says the jurisprudence of this nation has moved quickly away from the days when prosecutions were veritable ambushes on the accused. No documents or witness statements were made available to the accused, who had to do their best in cross-examining the witnesses whose testimony the accused would hear for the first time during the trial. This happened before. This is what used to happen before. Truth must be told, however, that the morphing of the role of prosecutor in today's criminal justice environment makes it difficult for the law enforcers negotiating the dynamics of criminal justice in the multifaceted role of the prosecutor is not an easy task, particularly for young or new prosecutors. It's possible for them to be immersed in a miasma of confusion and fall into error, which may lead to grave injustice. How do you cushion against arriving at just such injustices?
Well, let me start by saying that the office of the DPP takes the issue of respect for the constitutional rights and freedoms which are guaranteed under the Constitution very seriously. Mm-hmm. And as a public office, of course, under the national values and principles of governance under Article 10 of the Constitution, we are bound to respect human rights. And in the guidelines which we are lodging this morning, we have stressed throughout the guidelines the issue of adhering to human rights. Now, regarding criminal cases, what is it that we do to ensure that we uphold the rights and freedoms of suspects which are guaranteed under Articles 49 and 50 of the Constitution? Article 50 of the Constitution is the right to fair trial. Mm-hmm. I'll start by at the stage of investigations. And the DPP, the office of the DPP is only involved in investigations whereby we deem it fit to guide the investigators. But during investigations, the files which we get, we normally see correspondence between suspects and the investigating agency being called upon to come record statements and furnish the investigators with documents. Mm-hmm. So the suspects are aware always of what is happening because they've been called at one point in time to furnish documents and record statements. Some decline, some record statements. And we normally see this correspondence in the investigation files we normally get. When the case goes to court, the first thing is the charges are read to you, and the first thing which is done is the charge sheet is furnished to the accused person at that time, immediately, contemporaneously. At the same time the charges are being read, a copy of the charge sheet is provided. And then the court gives directions and orders on when the office of the DPP, the prosecution, should do disclosure on the evidentiary material they intend to rely on during the proceedings. Now, in some cases, we at the time of taking plea, in some cases, we already have those materials with us, and we furnish them at the time of plea. I will not say it is in all cases, but in some cases, we have the materials ready, the investigating agency has made copies, and they are furnished to the accused person at that time. The third thing which I want to mention is that we are now able to furnish the evidential material in digital form, either in a flash disk or whichever other form. But those who want hard copies, we have gone ahead to make provision for that through our office and in collaboration with the investigating agencies. We have done that. And there is no situation, there is no case in Kenya where we have proceeded before we have furnished all the evidentiary materials
to the
suspect. Yes,
but
I don't know any. Yes,
Victor, we've had a number of complaints, especially when it comes to the corruption cases where the prosecutor is presenting 10, 15 or 5 people before court. And before that, that is preceded by the prosecutor issuing a public statement or even calling a press conference to address a public statement, the public, and says, I have arrived at a decision to prosecute these particular individuals. Some of those individuals are hearing their name for the first time in that forum, in that they have never been called by the investigator, they have never been asked to record a statement, they have never been asked to give their side of the story. They're just hearing from the DPP that they are implicated and they're going to face charges.
Yes.
Why does that happen?
Let me start by saying that under Article 157, 10 of the Constitution, the DPP is an independent office. And in the discharge of our mandate, we don't require the consent of any person or authority to commence criminal proceedings or exercise our powers under Constitution, under functions under the Constitution. And we are also not bound by the directions or control of any person or authority. So we are an independent office. That is what I would say. But something else which you need to know. The public has got a lot of expectations from the office of the DPP, and the public has got the right to information. They must know what is happening with their country, and so the office deems it fit for the public to know and get this information. And there's nothing.
I'm not sure you got my question, Victor. I think the question here is specific to you want to go ahead and prosecute. You've already announced that you have cleared a certain file to go ahead for prosecution. And you're already directing the police to arrest certain suspects. But some of those suspects go ahead and complain that during the entire case of investigation, the investigating body never accorded them an opportunity to record a statement. When you're reviewing this evidence and you're going through the evidentiary threshold, don't you want to see statements from all the accused before you say that, yes, we are going to accuse so-and-so?
As I said from the beginning, we consider all the evidence, including rebuttal, evidence which is available. And it is, at times we return files to the investigating agencies to cover areas, and these areas could be a statement or document with the suspect. And as I also said, we are not involved in investigations unless we are guiding, where we see this is a complex case. It could be guided. We could be involved in guiding investigations and maybe in the agency collaboration mechanism. But it is, and we are not the ones investigating. But if we deem it fit at the time of review of the file that the suspect should record a statement and maybe furnish that document, we do it. We do it always. I think you answered, unless there is an aspect, and there is always a cobbling mechanism within our office. Quite a number of cobbling mechanisms. The first one is you can complain. If you are a suspect, complain to us in writing. Write to the DPP directly. Do communicate through social media, email, Twitter. Even the DPP himself picks up these messages personally. And we have a fully fledged complaints and compliment division, well staffed. You can also channel your complaints through there, and it will be acted upon immediately.
Okay.
Yes.
Okay, if I may
but of course, there are court mechanism if you are not satisfied by the decision.
If I may ask,
yes.
Does the ODPP have within its organization an arm that deals specifically with ensuring that each and every Kenyan has access to understanding what these services that you offer are and how it is that these services can benefit them as a citizenry?
Yes, we do. We do. We have, of course, we have an up-to-date website. What do you want?
Do you want a list?
No. Actually, where I'm going, a website is useful and it is a good beginning, but beyond the website, understanding that there's only a small elite, and I'm using the word elite here circumspectly because the number of people who have the tools to access any website in this country are not a majority, they are a minority. I am talking about the larger population of citizenry who don't have access, say, to internet. Or how do we reach these people? Because what I'm hearing is excellent. This is a sort of information that every citizen ought to actually have and know. But how do they access it?
Remember what I told you at the beginning. We are established in 129 stations throughout the country. Personally, I have served outside Nairobi. I am serving outside Nairobi. I'm serving outside Nairobi, in Kisumu, and I can tell you that we get members of the public visiting the office day in, day out. A lot of members of the public, and we welcome them. We listen to their complaints. We give them all the information they need, and that happens throughout the country due to our establishment. And we also have, in addition to the stations 129, we have offices in the 47 counties and all the sub counties. Offices operating fully manned. With offering all essential services, and where members of the public can get all the information they want about prosecution, their cases, whether they are even suspect. We even suspects even come to our offices physically. Even witnesses, victims, they come and we serve them as members of the public. I don't know whether you answered.
No, Mr. Mule, I don't doubt the earnestness with which the ODPP seeks to actually carry out its mandate. But remember, you are an independent unit within the government of Kenya.
Yes.
But your association is with other security forces that the Kenyan public doesn't lay very much trust in, like the police. Okay?
Yes.
Now, if people do not actually know. Forget those who want to come to you. People who come to you usually have a problem. I'm talking about those who have no problem. They have no issue. But it is important for them to know. Because from what you've said is someone needs to have a problem in order to come to you. Because otherwise, why would I want to come to the office of the DPP if I don't have a problem?
Yes.
In all honesty, like today's a Friday, I have 1 free hour. Let me take a stroll to the and a Kenyan doesn't think that way. Because
Yes.
the experiences that Kenyans have cumulatively with offices such as the ODPP is perhaps residual and historical. And what I'm asking is, what is it that the office is doing to bring the citizenry up to date in the 21st century with what it is that this new revamped office is actually doing and how it benefits them? That's what I'm asking.
Great. So now I get you. Have you heard of the outreach programs we've had? We've had community dialogue in informal settlements, not really informal, but we have had public dialogue in Kayole. We have had public dialogues in Mombasa. We have had public dialogues in Lamu. We have had public dialogues in Kisumu. And these public dialogues are led by none other the director of public himself, personally present. He fields questions from members of the public, the lowest members of the public,
So
and the
basically,
highest
these are
members of the public.
Public barazas.
Yes, public barazas.
How many do you
led
hold in
by
a year?
none other- Pardon?
How many do you hold in a year?
This year, I know we have held two, but since March, of course, due to the pandemic, we have not had. But last year, I know we had over 10 because we had public barazas in as I said, Kisumu. We had public barazas in Homa Bay. We went to Lamu. We went to Mombasa. We were in Isiolo. So we have been last year. We were also in Nairobi. Remember, for the public dialogue, and we also have very good collaboration with the civil society.
All right,
In
so
all
of
these
this
public
information,
dialogue,
Victor,
yes.
if I may ask you, all of this information that you now gather from these public barazas, just as an example, is this information that you then use to fuel the decisions you make? For example, now going into this revamped way of doing things, would you say
Yes.
that the information that you get from the public then influences the decisions that you then make in the future?
Of course, what happens during these barazas is we have forms. So we record each and every problem, and we come and analyze them. And then we use that. For instance, I will give you an example. We might not know what is happening on the ground, but through these barazas, we come to know that maybe members of the public have been mistreated by such and this and that group.
Yep.
Form a group which is maybe mistreating members of the public. So that influences us.
Yeah.
And then when we get back to the office, we act on these reports. We do letters to the Inspector General of the National Police Service to investigate.
Yep.
Others are also investigated by other agencies. If it is something like a land issue, we notify the National Land Commission. If it's a KRI issue and such like. If it is something to do with anti-corruption and economic crimes, we notify the Ethics and Anti-Corruption Commission to undertake. So in a way, some of the decisions come out of these public dialogues.
Do you hold these dialogues in collaboration with other state agencies? I'm imagining if you went to a small village, give me a village city, somewhere in Homa Bay,
Somewhere in Homa Bay.
or in Muhoroni, just somewhere before you get to
Tamu.
If you go to Tamu village, just before you, that's in Muhoroni, right?
Muhoroni, yes.
This is in Muhoroni. And the people there have various complaints. Of course, when they see government and they see the ODPP and the DPP himself, they'll come up with all manner of issues that are affecting them. I'm imagining if you went with other state agencies, say, for example, you had the Office of the Ombudsman present, you had the Inspector General of Police represented, the Ethics and Anti-Corruption represented, like you've just said, the Lands Ministry or somebody at least who's representing the committee that's chaired by CS Dr. Matiang'i present, then you'd be able to gather a lot more information and action can be taken faster. Or do you work independently when you go to Tamu?
the first thing, let's say we are going to Tamu, there are civil society organizations which are operating there. And the members of the public have got a lot of trust on the non-state actors, that is the civil society organizations. So the ones which are involved in the criminal justice system, we involve them. Secondly, of course, the local administration, the administrators.
Okay.
The public lives with these local administrators. We involve them because it's also them who know the people, they know the public, they know the area. But the most important thing I wish the public to know is that at the beginning of the public dialogue, again, none other than the DPP himself assures the public of their safety, the protection, the confidentiality of the information they are going to give. So we are able to gain confidence from the members of the public. They give us the information, either verbally or in writing. We have forms. We go along with staff who listen to complaints, they record them, they document them, and then once we get to the office, they are documented. So we don't do it independently. We do it as a multi-agency sort of initiative.
Okay, I'm just looking at carrying out of justice and asking going forward and how you then select these cases. Would you say that the same process goes across board, no matter the individual that is at the center of the stage, whether they have political affiliations or not?
In the selection of charges, we are not influenced by anything else apart from the sufficiency of evidence and public interest. Whether you are a politician, whether you are whatever religious organization you belong to, whatever race you belong to, we are not influenced. And that has never been the case in the office of the Director of Public Prosecutions. We select the charges which are disclosed by the evidence which has been presented to us by the investigating agencies. We don't consider the suspect, their background, or any other orientation. That is not a consideration. We are very objective and very independent in decision making. That one I can assure the public.
So, most recently, Victor, we see that, some cases, you talked about just previously, you talked about this effort being multi-agency, everybody basically throwing their hands into the pot and making sure that justice is dispensed, right? Just recently, we've seen some of these big cases that have taken years being asked to bring it down to at least 2 years to have all of this done. Previously, the office of the DPP has been seen to drag things out in terms of prosecution. Would you see now, with the court orders that have been given to say that 2 years is the maximum, with everybody putting their hands in the pot, do you see that prosecutory issues now can be whittled down to the 2 years?
Sure. It did. Let me put it this way. It did not been for this pandemic. This year, we would have concluded quite a number of cases. Concluded them, and for that matter, successfully concluded to our satisfaction, to the satisfaction of the public. And of course, now with the guidelines, and also today we are launching a case management system, which will involve document tracking, tracking the case to ensure that it is moving on expeditiously without any delays. And then we shall also be doing e-filing. So the process, the judicial process, will be faster. And again, we are also grateful to the judiciary. For instance, here in Nairobi, we have 9 anti-corruption magistrates. So we are able to give maybe up to even 2 weeks consecutively for hearings. And if you have 2 weeks in a case, depending on the length of witnesses, you are able to call quite a number of witnesses and conclude some cases. So we are seeing a situation whereby in future
Yeah.
cases will be concluded expeditiously without delay.
Thank
But
you.
remember, some of the factors which delay cases are not attributable to the office of the DPP. They are external factors. Some of them we have no control over. Thank you.
Thank you. Thank you very much, Victor Mule. He's the Senior Assistant Director of Public Prosecutions in the Office of the DPP. Thank you very much for shedding light on what how the ODPP works. And we wish you all the best this morning as you launch these new guidelines.
Yes, and you are welcome. You can join us on our website and join the lounge.
All right.
Thank you.
Asante sana.
Thank you.